Statute 600, 5.0704. 1. A court in a judicial proceeding brought to dissolve a limited liability company may appoint one or more receivers to wind up and liquidate, or one or more custodians to manage the business and affairs of the limited liability company. The court shall hold a hearing after notifying all parties to the proceeding and an interested person designated by the court before appointing a receiver or custodian. The court appointing a receiver or custodian has exclusive jurisdiction over the limited liability company and all of its property, wherever located. 2. The court may appoint a person authorized to act as a receiver or custodian. The court may require the receiver or custodian to post bond with or without sureties in an amount the court directs. 3. The court shall describe the powers and duties of the receiver or custodian in its appointing order, which may be amended. Among other powers, a. The receiver, 1. May dispose of all or a part of the assets of the limited liability company, wherever located, at a public or private sale, if authorized by the court, and 2. May sue and defend in the receiver's own name, as receiver of the limited liability company, in all courts of this state, and b. The custodian may exercise all of the powers of the limited liability company through or in place of its managers or members to the extent necessary to manage the activities and affairs of the limited liability company in the best interest of its members and creditors. 4. During a receivership, the court may redesignate the receiver as a custodian, and during a custodianship, may redesignate the custodian as a receiver if doing so is in the best interests of the limited liability company and its members and creditors. 5. During the receivership or custodianship, the court may order compensation paid and expense disbursements or reimbursements made to the receiver or custodian and the receiver's or custodian's counsel from the assets of the limited liability company or proceeds from the sale of part or all of those assets. 6. The court has jurisdiction to appoint an ancillary receiver for the assets and business of a limited liability company. The ancillary receiver shall serve ancillary to a receiver located in another state if the court deems that circumstances exist requiring the appointment of such a receiver. The court may appoint a receiver for a foreign limited liability company even though a receiver has not been appointed elsewhere. The receivership shall be converted into an ancillary receivership if an order entered by a court of competent jurisdiction in the other state provides for a receivership of the foreign limited liability company. We offer real estate, estate planning, probate, and business law. Call 321-206-3603 or visit easlerlaw.com to book a consultation. Offices in Melbourne, Florida. Virtual consultations worldwide.